of this case, I'm unsure why we can't go forward here today. And plus, even if a no contact order is entered, given the other orders in other places, I'm not sure, how your life would change at all. But go ahead, I'll hear from you. But I'm prepared to go today, and given how long and given the nature, and I've reviewed everything that's been submitted, including the petition and the and again the extracted stipulation of facts. And so I guess I'll hear from you as to why we can't proceed today on this. I'm going to guess that Ms. Sneeden and Ms. Weston very much want to get this over with here today. Go ahead.
Your Honor, I first would like to address the warrant in Pierce County, Washington. When that case was initially brought against me, I was in pretrial confinement in the military. And because I wasn't able to make it to court because of my confinement, they issued a warrant. And because I was in confinement until May 4th, 2025, that's why there's still an active warrant. And as of the 22nd, so this Thursday, I have a warrant quash hearing in Pierce County District Court.
Okay.
Or Superior Court, excuse me.
Okay. And so how long is that no contact order in military no contact order in place?
The military Your Honor, the military no contact orders are effective until 26 December 2025, when I'm no longer under jurisdiction of the military. And the Pierce County Superior Court, from my understanding from my attorney, is those will be permanent no contact orders issued from the court once the case has a final disposition.
So I guess what's the problem with entering no contact orders here? Because you can never, it's kind of impossible to predict the future. You never know what's going to happen in Pierce County. If the case goes away for some weird reason, then all of a sudden they're left unprotected. And once you get out of the military.
Your Honor, we have a plea agreement on the table. Like I said in my statement, the plea agreement is I'm pleading guilty to one of the charges. And when I plead guilty to one of the charges, the no contact order will be issued by the court. We're just waiting after the hearing to get a court date to sit down in front of a judge and actually sign the plea agreement.
Okay. Well, are you opposing this no contact order?
I would like to make statements. Yes, Your Honor. If 60 days is too much, I would like to request at least another 2 weeks so I can prepare my case. I didn't submit any documents because I was advised by my attorney not to.
Okay. Ms. Sneeden, and then I guess I'll hear from you just because you're on my screen first. Could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You can put your hand down. And then what's your position, first of all, on the request for a set over? And then I'll hear from you on the merits. And then go ahead first on the set over and then stop. And then I'll get Ms. Weston's input.
Okay, Your Honor. Well, first, I do not have a military protective order. Because of these events, I actually was discharged from the military. So there's nothing the military can do to protect me. I'm no longer on active duty service. I would like for this to move forward, and I have a bunch of points that I am ready to talk to you about today, Your Honor, that I've listed.
Okay. Ms. Weston, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
And then what's your position on, again, first of all, the request for a set over?
I would prefer to move forward today, Your Honor. This has been ongoing for many years, as you can see, and I would just like to get this over with.
Are you still on the military? Still in the military?
I am not, Your Honor. I got out of the military.
Okay. And so, Mr. Seeley, I'm going to come back to you. I'm going to hear from both petitioners. This case is, again, this case started in these series of incidents. Does this go back to 2020 or 2021? I'd have to look. I know when did all this start there, Ms. Sneeden?
2021, Your Honor.
Okay. And so I'm going to hear from them on the order, and then I'll hear from you. If you choose not to present information, that's up to you. But given that, again, there's a stipulation of facts in the record, which a lot of it's redacted, but I think I was able to figure out who people were talking about within the context of this case. We're going to go ahead and go forward today, and then I'll make a decision, and then we'll go from there. So Ms. Sneeden, I'll hear from you first.
Okay, Your Honor. So his criminal case that's brought up, I am listed as a witness for the state. So I'm working with them to provide them all the information, but he said he's pleading guilty. And then in the stipulation of facts, number 1314 is where it starts documenting his retaliatory and violent nature. So I obtained my MPO, and he broke into my apartment as revenge. When I got the CPO, so this is number 18 and 19 on the stipulation of facts, he faked that hostage situation, resulting in Pierce County SWAT coming, which is what his current criminal case is about. And then on page 34 of the exhibits, line 11 through 15, during the military court-martial, I testified about my fear that he would seek revenge by killing me, and he nodded, and this is on documentation. So I kind of just urged the court to go today, because also in the stipulation of facts, it shows that they had hired private investigators to follow us. So no contact orders do not protect us from the extents that they go to find us. He has already been found guilty for 2 counts of stalking, 1 for myself and 1 for Madison. And I guess I'm pleading to the court to protect us, because we really have no protection for the means that he is willing to go to find us.
Ms. Weston, you've previously been sworn. I'll hear from you.
Yes, Your Honor, I think Jacqueline really hit all of it, that there's a pattern of revenge and of threats of violence with Mr. Seeley. Even after all these years, I think that his anger about actions being taken to protect us and to stop him is just proven with the stipulation of facts and everything that is stated in those statements. Those are statements that he wrote, that he admitted to doing. I'm unsure of a Pierce County protection order. I never filed for one. I was never made aware of one. So as far as I'm concerned, I am unprotected right now.
So Mr. Seeley, could you raise your right hand, please? And do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Do you wish to say anything? You can put your hand down. Do you wish to say anything at this time? And
Yes, Your Honor.
I will say, before you do that, I want, on the information that I have, what they call JABS, or the Judicial Access Browser System, where I can see orders in different cases. Doesn't look to me like there's a no contact order in Pierce County Superior Court right now.
Yes, Your Honor. I have paperwork issued from the court when I went to my arraignment that says I will not have any contact with either Jacqueline Sneeden or Madison Weston. And that was from my arraignment, which should be able to be viewed from your system.
Okay, well, it's that's probably on the release order, which is a condition of release, is something different from a formal no contact order. So it might be a condition of your release you're not be able to, but that won't show up in a database as a formal no contact order.
Okay.
Which may be a distinction without a difference to you, but to me, there is a difference on that.
Okay. And then back to the MPO, the stipulations of my release for my discharge paperwork. It also says that my MPOs are still in place and I will have no contacts with my victims. So there's still no contact orders for the military side, which I'm under their jurisdiction until 26 December 2025, in which I have to report to a federal probation officer as well, which I listed her contact information and the paper that I submitted to the court, Your Honor.
Okay.
Also, I would like to bring up that in the stipulation of fact, it shows that I did not break into Jacqueline Sneeden's apartment that someone else did. All I did was return a firearm. And when it came to the court transcripts for my court martial, I will still object to that. I did not nod my head at Miss Sneeden to, I don't know what the word I'm looking for is, to annotate that I was going to come after her for revenge. I still object to that. She also did say it's going to be a who shoots first, so I take that as a threat, and I did file that in my first appeal from my military court as taking that as a threat, as it's going to be a who shoots first scenario. And those are words coming out of her mouth. Also, during my pretrial confinement, Miss Sneeden and Miss Weston felony vandalized my vehicle. I wasn't able to submit pictures to the court, but while it was in before it was in CID custody, immediately within 24 hours after my arrest, my window was broken out. There was a hatchet taken to the side of my door. My mirror was busted out, and it was over $14,000 worth of damage done to my truck after I was arrested. And only the victims and my chain of command in the military knew where I was staying, because I was not staying in my home. I was staying in a different barracks on post with a different unit. And like I said, only Miss Sneeden and Miss Weston and the chain of command knew where I was staying.
Your Honor, I'd like to speak on that.
Okay. And while I wait till he's done, anything further there, Mr. Seeley?
Yes, Your Honor. I noticed that both in Miss Sneeden and Miss Weston's statements, they said that it had been 2 years of harassment. I would like to object to that. I started harassing them in July of 2021, and I stopped harassing Miss Sneeden, and it's stated in the stipulation of fact with dates for February 2022 and March 2023 for Miss Weston. And it says in the stipulation of fact that one of my family members, aka my mom, started harassing these two. So I was not harassing these individuals for 2 years. It was only a period less than 8 months and 6 months for the harassment. And then she claimed that I was harassing them or stalking them. I think it was Miss Sneeden said that in her statement, said that I was still harassing her and stalking her during my court martial, but I was in pretrial confinement. I was in jail. I could not stalk her. And I believe that to just be a blatant lie.
Anything further?
As of right now, unless anything else is brought up, that is it for now, Your Honor.
Okay. Ms. Sneeden, was it Ms. Sneeden you wanted to address that?
Yes, Your Honor. So first of all, I did not know where Mr. Seeley's truck was, so that was a lie. I have never damaged his vehicle, nor have I wanted to go around him. When you're a victim of stalking and the harassment and the violence that we were, you would not want to go near anything of theirs because you don't know what's going to happen. He also took the part of the court martial out of context. When I was asked, how do I think this will end? After I said that, I testified that he nodded, and that's on the record. I said that I think he will kill me, and I would try to defend myself if he were to break into my home. The last thing I would like, what did he just said I was blatant lying. I have not lied on record, Your Honor, is the point. I never damaged his vehicle. I don't know where these accusations are coming from. They're baseless. And it goes to show that he is still angry. And I think it emphasizes his history of retaliation. And my voice is starting to shake because I have dealt with this for years and I know his anger. And it's just showing that none of it's resided, Your Honor. If anything, we are definitely still in danger.
And Ms. Weston, did you wish to have anything to add or no?
Yes, Your Honor. As far as the damage to his vehicle, this is the first that I'm hearing of it, and I would really like that stricken from the record because there's no proof that her or I had anything to do with this. As I said, this is the first I'm hearing about it. I had no idea where he was staying and didn't know that his truck was vandalized. This is 2.5 years later, and I'm just hearing about it for the first time. So I would like that to be taken out of consideration. Also, the court-martial transcript clearly states that, and I think it's in the testimony, maybe not the stipulation of facts, that his mother was harassing us on behalf of him. as well as the burglary to our home was on behalf of him.
So Mr. Seeley, I'll give you the final word. Anything you'd like to say at this time?
Yes, Your Honor. I do not have any current ill will towards Miss Needham or Miss Weston. I have no interest in hurting them, stalking them, anything. I understand why they're upset. I did my time. I pled guilty to the charges for the military. I accepted the first no contact order. The first no contact order wasn't violated. I understand where they're coming from, but at the same time, I have no interest in Miss Needham or Miss Weston. I understand that they fear for their life, but there's no reason for them to fear for their life. As it states in the stipulation of fact, all I wanted to do was make them fear, not actually hurt them. I have no violent history, no violent past. I've never actually physically threatened anybody. So I don't know where they're getting that I'm physically aggressive, because I've never hurt them or anybody, and that's court factual. As far as my vehicle goes, I still stand by that statement, because they were the only two that knew where I was, to include the chain of command. And I know the chain of command wouldn't damage my vehicle, and it just so happened that within the first 24 hours that I was arrested, that my vehicle was damaged. Because if I was able to submit documents, I would be able to submit pictures, the pretrial confinement magistrate's notes where the CID officer says that my vehicle was found damaged. And then there's other documentation that I would submit also, that Miss Needham said that she didn't, they're blatant lies that I said that she made. It's right in front of you, Your Honor. She's making statements in her, she's making statements on her individual documents that contradict what the stipulation of fact from the court martial says that she had to agree to in order for the prosecution to sign. So there are discrepancies.
Okay, so here's where I'm at on this case. Give me just a second. So these aren't criminal cases. These are civil cases for anti-harassment. If someone's harassing or somebody else, they can come to court, ask for an order for no contact. Unlawful harassment is defined as following: as a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, harasses, or is detrimental to such person, and that serves no legitimate or lawful purpose. The course of conduct must be such as would cause a reasonable person to suffer substantial emotional stress, and must actually cause substantial emotional distress to the petitioner, or in these cases, two petitioners. Course of conduct is just defined as a pattern of conduct, composed of a series of acts over a period of time, however short, evidencing continuity of purpose. In this case, I'll make the following findings. Contained in the record, there's a timeline of events outlined by the petitioners. This all began in July of 2021 with Mr. Seeley, Ms. Sneeden, Ms. Weston were all in the military. Ms. Sneeden was in a position as a victim advocate through some fairly sophisticated manipulation, deception, impersonating other people. Mr. Seeley began a series of contacts, a course of conduct, which really had no other purpose other than to frighten, intimidate, or harass Ms. Sneeden. In fact, Mr. Seeley, one of his comments, I was kind of struck by your comment when you said, well, I didn't harass them for 2 years. I only harassed them for 8 months. Shouldn't have been harassing them at all. 8 months is, I'm not making a finding for exactly how long this went on, even though you may have stopped. I mean, the feelings and the reaction to Ms. Weston and Ms. Sneeden is going to continue, and based on their body language and demeanor, it's probably continuing till now. You could say, well, they don't have any reason to fear me and all that sort of stuff, but I understand why they would continue to feel that way. You have said that you bear them no ill will or don't want any contact to them. That's good. I hope you mean that. But I am going to enter orders today. And these civil orders, they can't do them indefinite. Typically, the default position is a year, but in this case, given the level of harassment that I've seen that's contained in the file, both with the stipulated extraction of facts, I'm not sure I said that right, combined with the statements of Ms. Weston and Ms. Whedon, combined with the transcript of the military, I guess, tribunal, they call it. I'm not sure they call that. That was a hearing of some sort or a trial within the military. I've never been in the military. I'm not sure specifically what that was called, but the order is going to be in place for both of you are going to be in place for 5 years. And so, you know, and Mr. Seeley, again, this should be, I'm hoping this just makes it easy for you. It draws a bright line. You say, well, there's an order. They say, well, we're not sure about that. I don't see an order in Superior Court. I tend to, what Ms. Sneeden says makes a lot of sense, that if he's not in the military order may not bring much protection or comfort for her, but there's going to be an order here. You understand that?
I understand, Your Honor.
And you're not to have any contact with them, not engage in stalking, don't come within 1,000 feet of them, their residence or place of employment. And they're just not in any way a part of your lives. Do you understand that?
I understand, Your Honor.
And, you know, and I'm also sensing one thing that maybe is, you know, in some way, it seems to me like you're kind of trying to shift blame from yourself to them. But this order's in place. You spent time in the military facility and are being prosecuted in Pierce County Superior Court because of your actions. And I hope you understand that. These two individuals are not to blame.
I understand.
And so the order will be extended for, the order will be in place for a period of 5 years. And like I say, and you can get copies of this. All of you can get copies of this, or actually, do we have their email to send it to them? The petitioners will have an email. It'll get sent to you that the email is that you provided. And if we have your email, Mr. Seeley, you'll get a copy of it also.
Okay.
Your Honor.
And we do have that. And then you folks are free to go. You'll get
May
a
I ask
copy of
one
the
question,
order
Your
later
Honor?
today. What's that?
May I ask one question, Your Honor?
Yes.
Will this also include like no third-party surveillance?
Yeah, and that includes third-party contact. And then that's directly or indirectly. So yes, is a short answer. If you have someone on your behalf bothering these people, and I understand that may be disputed, but nonetheless, if you have anybody do anything on your behalf with regard to these two individuals, most courts, I know I certainly would consider this a violation of the order. Do you understand that, Mr. Seeley?
Yes, Your Honor.
It's done with these folks in any way, shape, or form.
I understand, Your Honor.
Great.